Good morning, everyone. Now let's start with the chapter number 4 Preamble of the Constitution. The American Constitution was the first to begin with preamble. Many countries, including India, followed by this practice. The term preamble refers to the introduction or the preface of the Constitution. It contains the summary or essence of the Constitution. N.A. Palkhiwala, an eminent jurist and the constitutional expert, called the preamble as identity card of the Constitution. The preamble to the Indian Constitution is based upon objective resolutions drafted and moved by Pandit Nehru and adopted by Constituent Assembly. It has been amended by 42nd Constitutional Amendment Act 1976, which added three new words: socialist, secular, and integrity. Text of Preamble. The preamble in its present form reads as: We, the people of India, having solemnly resolved to continue India into sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Ingredients of Preamble. The preamble reveals four ingredients or components. First, source of authority of Constitution. The preamble states that Constitution is derived its authority from the people of India. Second, the nature of state. It declares India to be sovereign, socialist, secular, democratic, and republic polity. Third, objectives of Constitution. It specifies justice, liberty, equality, and fraternity as its objectives. Fourth, date of adoption of Constitution. It stipulates the November 26, 1949 as a date. Keywords in the preamble. Certain keywords like sovereign, socialist, secular, democratic, republic, justice, liberty, equality, and fraternity are explained as follows. First, sovereign. The word sovereign implies that the India is neither a dependency nor a dominion of any other nation, but an independent state. There is no authority above it, and it is free to conduct its own affairs, both internal and external. Though in 1949 India declared the constitution of her full membership the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth. This extra constitutional declaration does not affect the India's sovereignty in any manner. Further, India's membership of the United Nations Organization UNO also in no way constitutes a limitation on her sovereignty. Being the sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of foreign state. Second, socialist. Even before the term was added by 42nd Amendment in 1976, the Constitution had socialist content in the form of certain directive principles of state policy. In other words, what was hitherto implicit in the Constitution has now been made explicit. Moreover, the Congress party itself adopted a resolution to establish a socialistic pattern of society in its Awadhi session as early as in 1955 and took measures accordingly. Notably, the Indian brand of socialism is a democratic socialism and not a communalistic socialism, also known as a state socialism, which involves the nationalization of all means of production and distribution and the abolition of private property. Where democratic socialism, on other hand, holds faith in a mixed economy where both public and private sectors coexist side by side. As Supreme Court says, democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. Indian socialism is the blend of Marxism and Gandhism, leaning heavily towards Gandhian socialism. The new economic policy of 1991 of liberalization, privatization, and globalization has, however, diluted the socialist credentials of Indian state. 3. Secular. The term secular too was added by 42nd Constitutional Amendment Act of 1976. However, as Supreme Court said in 1974, although the words secular state were not expressly mentioned in the Constitution, there can be no doubt that Constitution makers wanted to establish such a state that and accordingly Article 25 to 28, which are guaranteeing the fundamental rights to the freedom of religion, have been included in the Constitution. The Indian Constitution embodies the positive concept of secularism, that is, all religions in our country, irrespective of their strength, have same status and support from the state. Fourth, democratic. A democratic polity, as stipulated in the preamble, is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. Democracy is of two types, direct and indirect. In direct democracy, the people exercise their supreme power directly, as the case in Switzerland. There are four devices of direct democracy, namely referendum, initiative, recall, and plebiscite. The Indian democracy, on other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and make the laws. This type of democracy are also known as representative democracy, is of two kinds, parliamentary and presidential. The Indian Constitution provides for the representative parliamentary democracy under which executive is responsible to the legislature or for all its policies and actions. Universal adult franchising, periodic elections, rule of law, independence of judiciary, absence of discrimination on the certain grounds are the manifestations of democratic character of Indian polity. The term democratic is used in the preamble as a broader sense, embracing not only political democracy but also social and economic democracy. This dimension was stressed by Dr. Ambedkar in his concluding speech in Constituent Assembly on November 25, 1949 in the following way. Political democracy cannot last unless there lies the base of it, social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity. The principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from the equality. Equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty could produce the supremacy of few over many. Equality without liberty would kill individual initiative. In the same context, the Supreme Court observed in 1997 that the Constitution envisions to establish the egalitarian social order, rendering to every citizen social, economic, and political justice in a social and economic democracy of Bharat Republic. Fifth, Republic. A democratic polity can be classified into two categories, monarchy and republic. In the monarchy, the head of the state, usually king or queen, enjoys the hereditary position, that is, comes into the office through succession. Example, Britain in a republic or on the other hand, head of the state is always elected directly or indirectly for a fixed period. For example, USC. Therefore, the term republic in our preamble indicates that India has an elected head called president. He is elected indirectly for the fixed period of 5 years. A republic also means two more things. One, vesting of political sovereignty in the people and not in the single individual like king. Second, the absence of any privileged class and hence all public offices being open to every citizen without any discrimination. Sixth, justice. The term justice in the preamble embraces three distinct forms of social, economic, and political, secured through various provisions of fundamental rights and directive principles. The social justice denotes equal treatment of citizens without any social distinction based on the caste, color, race, religion, sex, and so on. It means absence of privileges being extended to any particular section of society, and improvement in the conditions of backward classes, SCs, STs, and OBCs, and the women. Economic justice denotes the non discrimination between the people on the basis of economic factors. It involves the elimination of glaring inequalities in wealth, income, and property. A combination of social justice and economic justice denotes what it is known as a distributive justice. Political justice implies that all the citizens should have equal political rights, equal access to all political offices, and equal voice in the government. The ideal of justice, social, economic, and political has been taken from the Russian Revolution 1917. Seventh, liberty. The term liberty means the absence of restraints on the activities of individual, at the same time providing opportunities for the development of individual personalities. The preamble secures to all citizens of India liberty of thought, expression, belief, faith, and worship through their fundamental rights enforceable in a court of law in case of violation. Liberty, as elaborated in the preamble, is very essential for the successful functioning of the Indian democratic system. However, liberty does not mean license to do what one likes and has to be enjoyed within the limitation mentioned in the Constitution itself. In brief, liberty conceived by the preamble or the fundamental rights is not absolute but qualified. The ideals of liberty, equality, and fraternity in our preamble have been taken from the French Revolution. Eighth, Equality. The term equality means the absence of special privileges to any section of the society and the provision of adequate opportunities for all individuals without any discrimination. The preamble secures to all citizens of India equality of status and opportunity. This provision embraces three dimensions of equality: civic, political, and economic. The following provisions of the chapter of fundamental rights ensures equality. First, equality before law, Article 14. Second, prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth, Article 15. Third, equality of opportunity in the matters of public employment, Article 16. Fourth, abolition of untouchability, Article 17. And fifth, abolition of titles, Article 18. There are two provisions in the Constitution that seek to achieve the political equality. 1. No person is to be declared ineligible for inclusion of electoral rolls on the grounds of religion, race, caste, or sex. Article 325. And 2. Elections to the Lok Sabha and the state assemblies to be on the basis of adult franchise. Article 326. The Directive Principles of State Policy, Article 39, secures to men and women equal right to an adequate means of livelihood and equal pay for equal work. Ninth, fraternity. Fraternity means a sense of brotherhood. The Constitution promotes this feeling of fraternity by the system of single citizenship. Also, the fundamental duties, Article 51A, says that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst the all people of India, transcending religious, linguistic, regional, or sectional diversities. The preamble declares that the fraternity has to assure two things: the dignity of individual and the unity and integrity of nation. The word integrity has been added to the preamble by 42nd Constitutional Amendment 1976. According to K. M. Munshi, a member of drafting committee of the Constituent Assembly, the phrase dignity of individual signifies that Constitution not only ensures the material betterment and maintain a democratic setup, but that is also recognizes that the personality of every individual is sacred. This is highlighted through the sum of the provisions of fundamental rights and directive principles of state policy, which ensures the dignity of individuals. Further, the fundamental duties, Article 51A, also protects the dignity of women by stating that it shall be the duty of every citizen of India to renounce the practices derogatory to the dignity of woman, and also makes it a duty of every citizen of India to uphold and protect the sovereignty, unity, integrity of India. The phrase unity and integrity of the nation embraces both psychological and territorial dimensions of the national integration. Article 1 of Constitution describes India as the union of states to make it clear that the states have no right to secede from the union, implying the indestructible nature of the Indian Union. It aims at overcoming hindrances to the national integration like communalism, regionalism, casteism, linguism, secessionism, secessionalism secessionism, and so on. Significance of Preamble. The preamble embodies the basic philosophy and fundamental values, political, moral, and religious, on which the Constitution is based. It contains the grand and noble vision of Constituent Assembly and reflects the dream and aspirations of founding fathers of Constitution. In the word of Sir Alladi Krishnaswamy Iyer, a member of Constituent Assembly, who played a significant role in making the Constitution. The preamble to our Constitution expresses that we had thought or dreamed so long. According to K. M. Munshi, a member of drafting committee of Constituent Assembly, the preamble is the horoscope of sovereign democratic republic. Pandit Thakur Das Bhargava, another member of the Constituent Assembly, summed up the importance of preamble in the following words. The preamble is the most precious part of the Constitution. It is the soul of Constitution. It is the key to the Constitution. It is the jewel set in the Constitution. It is the proper yardstick with which one can measure the worth of the Constitution. Sir Ernest Barker, a distinguished English political scientist, paid a glowing tribute to political wisdom of the authors of Preamble. He described the Preamble as a keynote to the Constitution. He was so moved by the text of Preamble that he quoted it at the opening of his popular book, Principles of Social and Political Theory, 1951. M. Hidayatullah, the former Chief Justice of India, observed, Preamble resembles the Declaration of Independence of United States of America, but it is more than a declaration. It is the soul of our Constitution, which lays down the pattern of our political society. It contains a solemn resolve which is nothing but a revolution can alter. Preamble as a part of Constitution. One of the controversies about preamble is as to whether it is a part of Constitution or not. In the Berubari Union case 1960, the Supreme Court said that the preamble shows general purpose behind the several provisions in the Constitution and thus a key to the minds of the makers of the Constitution. Further, where the terms used in any articles are ambiguous or capable of more than one meaning, some assistance of interpretation may be taken from the objectives enshrined in the preamble. Despite this recognition of the objectives enshrined in preamble, the significance of preamble, the Supreme Court specifically opined that the preamble is not part of Constitution. In the Kesavananda Bharati case, 1973, the Supreme Court rejected the earlier opinion and held the preamble as a part of Constitution. It observed that preamble is of an extreme importance and Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. In the LIC of India case 1995 also, Supreme Court again held that the preamble is an integral part of the Constitution. Like any other part of the Constitution, the preamble was also enacted by the Constituent Assembly, but after the rest of the Constitution was already enacted. The reason for inserting the preamble at the end was to ensure that it was in conformity with the Constitution as adopted by Constituent Assembly. While forwarding the preamble for votes, the President of Constituent Assembly said, the question is that preamble stands the part of a constitution. The motion was then adopted. Hence, the current opinion held by Supreme Court that the preamble is part of constitution is in consonance with the opinion of the founding fathers of the constitution. Moreover, two things should be noted. First, preamble is neither a source of power to the legislature nor the prohibition upon the power of legislature. Second, it is non-justiciable in nature that its provisions are not enforceable in the courts of law. Amendability of Amenability of the preamble. The question is as to whether preamble can be amended under Article 368 of the Constitution arose for the first time in the historic Kesavananda Bharati case of 1973. It was urged that the preamble cannot be amended as it is not a part of constitution. The petitioner contended that amending power in Article 368 cannot be used to destroy or damage the basic elements or the fundamental features of the Constitution, which are enshrined in the preamble. The Supreme Court, however, held that the preamble is a part of Constitution. The court stated that the opinion tendered by it in the Berubari Union 1960 case in this regard was wrong and held that the preamble can be amended subject to the condition that no amendment is done to the basic features. In other words, the court held that the basic element or the fundamental feature of the Constitution as contained in the preamble cannot be altered by amendment under Article 368. The preamble has been amended only once so far in 1976 by 42nd Constitutional Amendment Act, which has added three new words socialist, secular, and integrity to the preamble. This amendment was held to be valid. Thank you. Here we complete with the chapter number 4, the preamble of Constitution. If you find this audiobook helpful in your preparation at any point of time, then please do not forget to like, share and subscribe to these videos and subscribe to my channel UPSC Shorts. Thank you. Have a good day.